session.
Good morning. Please be seated. We are here for oral argument in case number 1CA JV18 0322, Donald W. versus DCS. These proceedings are being audio and video recorded, so we would ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellate's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you choose to do that. We have read the briefs. We've discussed this case in conference this morning. And counsel, you may begin.
If it pleases the court, my name is Denise Carroll, and I'm representing Donald W. in this case, the appellant. It was kind of hard to decide how to start this case because there's just something unsettling about it. The issues that are presented today are whether reasonable and diligent efforts were made by DCS in trying to preserve the family of Donald W. and to see if he would be reunified with his daughter.
Before you get there, counsel, I do have a couple of questions I would like to ask you if you don't mind.
No problem.
Why did father in this case submit the dependency allegation to the court when there was no factual evidence to support the dependency petition as it related to him?
Right. And I can only read from what all of the different papers that I've had. He was represented by Mr. Lopez down below. He was living in Sacramento. He had some financial issues. I think sometimes a parent, and I think in this case, it's more of a decision of, am I ready to take this child back? At the point when we were at the dependency, he had no relationship with this child. And if your honors are familiar with the timeline, the child was born in 2014. It took almost a year by the time that they did the ICPC.
Hold on, because the dependency here, when they submitted it, was within, what, 4 months?
Correct.
Because when the paternity test came back, and that would have been, what, in April of 2015?
Correct, 2015.
And so then they had the initial dependency hearing where they submitted the issue.
Right.
At that point in time, was there anything in the record that would indicate the father was an unfit parent?
Nothing. There's nothing.
Well, why would you submit it then?
Well, I think, like I said, Judge, I mean, at that point, a decision has to be made by the parent. They get advice from their attorney below.
So, counsel, are you representing that at that point in time, father was not ready, willing, and able to take care of this child? I did not see that in the record.
And, Judge, I'm
Are you speculating?
Speculating at this point.
Okay.
Well, try not to do that, because the question was,
right,
what is in the record?
Right. And I don't think there is anything. I believe that at the point of dependency, that this child, as soon as the ICPC was granted, should have been returned immediately.
Well, I have a question further upstream from the ICPC.
Okay.
Once paternity is established in the client,
Right.
there's no allegation of fitness as to him.
Right.
What authority does DCS have once paternity is established to not immediately, or whatever the bureaucratic requirements are, to turn the child over to father?
Well, I guess what you're asking is, besides having the ICPC, could the father have just come from California and said, give me this kid? And I believe he probably could have. And I think that they probably should have had a hearing at that point to determine if there was a reason why he shouldn't have that child. Now.
Oh, well, there's a rule for that, right?
There is a rule. And
he didn't file a motion.
He did not file a motion. He did not.
And when we look at the record, there is no indication other than our speculation that counsel performed efficiently. That's the only thing that I can come up with.
Right.
Have you found anything in the record that would illustrate that father was aware he could and chose not to?
There's nothing in the record. There's nothing in the record. I mean, from what I understand, just making a timeline of what happened in this case, and father's own testimony in both the July 2017 and the July 2018 was that there was a period where he was not working. He was depending on his counsel. His testimony is, I've been ready since day one to take my child, which is why he contacted DCS in January of 2015 to say, I'm here. Now, of course, I don't dispute that a paternity test had to be done. I mean, that was something we had Mr. Dixon as the other father in this case, and there had to be some kind of verification that this was in fact the father. But I do believe that after the paternity test results were received and he was in fact the father, that Mr. Lopez could have filed a motion asking that the child be returned to the father.
So the finding of paternity, just to make sure I'm tracking this timeline, came before or after he submitted to the dependency in court?
I believe it was after.
Well, it couldn't have been before because
Yeah, it was.
you would have a dependency because you're not a party.
Correct. Correct, yeah.
So he agreed the allegations in the dependency petition were true, or submitted them.
Right.
Is there anything in the record that supports any of the allegations in regard to father contained in that petition?
I do not believe so. I do not believe so. Of course, I'm his counsel, but at that point, in looking at the situation, I don't necessarily agree that he should have submitted, and that it wasn't probably more appropriate to go to a full trial on that. Whatever the confidential reasons between him and his counsel were, I'm not aware of, and there's nothing that I can see in the record that would support, that there may have been reasons outside of what we see in the record.
Well, counsel, it seems like counsel should have, or your client should have done something early on to demand custody of the child, because there were no allegations of a fitness as to him.
Right.
But all that said, what were DCS's obligations with the lack of any allegation to turn the child over?
Well, I think DCS did have an obligation. I understand the idea of getting the ICPC, although in this case, I don't think there was anything that showed that father was unfit. I mean, I do believe that he could have driven from California the day after the paternity result and filed a motion to get custody of the child. That's what I believe, okay? That wasn't done. What would be the next step? If a dependency is found, then they have to get the ICPC. That's required. They get the ICPC, and at that point, once it's approved, he should have gotten the child back right then and there. I mean, this whole idea of this transition, this child was 1 year old at that point.
And did your client demand the child back? Or back? Did he demand the child once the ICPC came out?
And I believe, Judge, looking through the minute orders, I mean, he participated in every hearing, and I believe his position was that he wanted the child back. He was told that there had to be this transition period of which time he would get to know this child, and that he would be required to come out, of which he did. He did come out.
You would agree with me, there is nothing, if he hadn't submitted to the dependency, there would be absolutely nothing that would impose that kind of a requirement on a biological parent.
I agree. If I could go back and redo this, I would redo it. But we have what we have. And we have a parent that in no way has been shown to be unfit, that, the department has kind of set up these rules. And I don't see anything in the ICPC statute that requires this transitional period, which they suggested. And just as an experienced attorney who's been doing this for a dozen years, this case is unusual. Usually the department, once the ICPC goes through, they have the obligation to get that child to the biological father. They didn't do it. And so if you ask me at what point, well, sure, there were several points. But absolutely 100%, when that ICPC was issued, that child should have been returned. And they didn't do it.
And whose fault is it that that issue wasn't pressed to the trial court?
Well, I think DCS has an obligation, just in their own governing of their own ruling, that they should understand that when ICPC comes through, this is their obligation. Should the defense attorney? Maybe he should have. But DCS has to self-rule. These are not adversarial. We're all working for the best interest of this child. So if DCS has an obligation to follow the law, and if the law says that you do an ICPC and the child's dependent, and that ICPC comes back that child can go back to father and that parent is fit, that child should be returned. That's it. It shouldn't be a motion or whatever. Departments should step up to the plate and do what they had to do, and they didn't.
And when they don't, who's responsible to make sure they do?
Well, I think that partially it's the court. I mean, the court was aware. You go back through the minute orders. The court was aware that through the court reports that the ICPC had come back. The court was aware that the ICPC was granted, and the court was also aware what the allegations. And if you had seen the July 2017, Judge Brotherton, he talks about it. He says, look, there is an abandonment here. I don't know what they're talking about. He was unsettled by this case. He denied the motion for termination because he said this is not what the legislature intended. This case shouldn't be here. And he went and tried to bend over backwards to get this child back home.
But counsel, just so we're clear, what you've represented to us at this point in time is father submitted the dependency. It was found that he was dependent and he never appealed.
That's correct.
And then the ICPC comes back in saying the father is fit. Rule 59 would have allowed him to file a motion, which he didn't file.
Correct.
And so everything is to blame on DCS and not on your side.
No.
Is that what you're representing to us?
No, I'm not representing that. That wouldn't be fair to DCS either. I mean, there was a lot of errors made in this case. I mean, as an attorney that represents parents, absolutely, a Rule 59 should have been filed. Absolutely, when the father was first identified through the paternity test, maybe the attorney should have stepped up and said, look, drive over here and I'm going to get your kid back. I mean, there was a lot of things done. But really, at the end of the day, we have to say, look, defense attorney made mistakes, DCS made mistakes, the judge made mistakes, everybody made mistakes. But at the end of the day, can we deprive this man of his child?
Well, let's get to that last severance hearing. Okay. And in the last severance hearing, the way I read the order, the only finding for the severance for the 15-month that would indicate unfitness is lack of bond. Do you agree with that?
Well, I guess I read it a little bit differently. I mean, I read it as that, his failure to visit.
That's part of the lack of bonding.
I mean, the bonding assessment, which, by the way, was done quite late in this case. This wasn't done initially. But this lack of bond was more of a best interest than it was unfitness.
Well, that's my point.
Visitation is the only unfitness issue.
Are you aware of any case that holds that a lack of a bond or lack of bonding, I don't know if that's the correct way to say that, shows unfitness?
No, but there's no case that shows that. It's not part of the statute. That's not, I think there's kind of this intertwining. We have two separate ideas, and I think the Alma case that was just up in the Supreme Court really laid that out. And I think it's pretty clear now to us practitioners that, we have to show unfitness first before we can even get to best interest. And if you can't show unfitness, you can't, dribble some of the best interest, the bonding in there. It doesn't work that way. It's not supposed to. You first have to show he's unfit, and I think the only thing, and maybe this is giving too much to the trial judge, is to say, she said, look, he didn't visit. If he had visited more, not bonding, but visit, that was a service he was supposed to do, he didn't do the service. That's the only thing she really relied on in finding he was unfit, that he didn't visit enough. But I don't even think that pertains to what the statute is intended to do. So I don't think there was anything to show he was unfit. I mean, she discounted the fact of the domestic violence that happened in 2004. There wasn't any illegal substance, although that was an issue that was sort of brought up. But that was not in the ruling whatsoever. The only issue was that he didn't do enough visitation.
And he didn't visit enough because couldn't afford.
He didn't have the money. Yeah, he didn't have the money. I mean, that's sad. I mean, here's a working man. He's making, he said, between $12 and $14 an hour. He's scrambling to get jobs. He's getting fired from jobs because he's got to come out to Arizona. And if you saw, as soon as that decision came back, he came out in September. He came out in October. The DCS goes back and they keep changing this order. So now they only have to reimburse. And then he can't afford to come out in November. And they say, well, now you haven't come out enough. You violated the judge's orders. I mean, I don't think that's fair. It's just not fair to this guy. And to be honest, there was a lot of better ways that DCS could have handled this case. I mean, they could have had the foster mom go out there and stay 2 weeks and integrate this kid. They could have had the case manager bring the child. There was a lot of ways when that first ICPC was approved that they could have handled this case a lot better.
What is DCS's responsibility to provide funding to achieve visitation?
Because the bottom line is that the whole purpose, I believe, of DCS is to keep families, to provide services to keep families together. We recognize that constitutionally you have a right, a fundamental right to have a family together, and DCS through the legislature is empowered with this ability to give services. No different than when they pay for counseling and they pay for drug treatment and they do all of these things. In this case, we had only one service we really needed, and that service was to get this father to come over here and be able to bond with his child for a period of time. At least that's what the court felt. I mean, I would kind of disagree with that, but they felt that was important.
And none of that experience would be necessary had they given the child over either when paternity was established
Right.
or after the ICPC.
You're right. They wouldn't have had to pay that. You're right. And if they had done it, I mean, the child would have been at an age of a year, and, any trauma would have been forgotten when she grew up. So, I mean, now saying, well, she's 4 years old and she's bonded to these foster parents, sure, but when the ICPC was granted, she was only a baby. She would never probably even known the difference. So, yeah, there was a lot of mistakes done. But I think at the end of the day, and I'm going to reserve the rest of my time, but at the end of the day, what we're asking the court is to give this child back. This should never have been here. We should never be at this point.
What specific relief are you asking this court to do?
I'm requesting that this severance be overturned, that it be sent back with a mandate that this child is to be returned to the father. That's what I'm asking for. And I think it should be done immediately. And if DCS wants to soften the blow with this child by bringing that child out there and having the foster parents say, they can do it, but they have to return this child. That's what I'm asking for. Thank you.
Thank you, counsel. Counsel.
If it please the court, my name is Sandra Nahigian. I'm the Assistant Attorney General representing the Department of Child Safety. I wanted to first respond to their request that the child be immediately turned over. There is no ICPC approved in California, so this child cannot be turned over to father at this time until he resolves the issues there, which was concern about his lack of consistent employment and his renewed use of marijuana. So until that gets resolved.
Hold on, because he has a medical marijuana card.
He does, but
okay, so that's off the table. So tell me.
Well, it's not off the table, though, if they are concerned about it, and that's one of their concerns about whether he can or can't parent.
Because it was a point in the time when he didn't have the card, but now he does have the card.
But just like alcohol is legal, the fact that you can legally use marijuana does not mean you automatically get to use marijuana without any investigation. You have to ensure that he's using it safely.
Can we back up to the beginning of the case?
Sure.
Okay. So, mom's in California. Baby is created. Mom moves to Arizona. Baby is born. Father, within 1 month, contacts DCS and says, I think I'm the daddy.
Yes.
There's a huge delay in getting that paternity test ordered and completed. I'm going to say 7 months is too long. But once that happened, under what authority did DCS maintain and retain custody of this child? Typically in a dependency action, there has to be some finding. And DCS submitted a dependency petition with allegations that had absolutely no factual support. So when we look at this, was it father's failure or DCS's misrepresentations to the court that made this case go so horribly askew?
I don't know that it was a misrepresentation if the
Okay,
child
well,
is...
explain to me where in the record you have abandonment and neglect as it relates to father.
Simply the fact that father's in, at that point, father's in California. We can't send the child to California.
No, that's not what I'm asking. Tell me where in this record you have evidence that would indicate father is unfit and he abandoned or neglected that child at 1 month. Because that's when your petition was filed.
Yes.
Where is it?
Well, it's partly it was to determine paternity. That was, the petition included a paternity determination.
Okay, well, that's not answering my question, is it?
I can't answer your question.
Because there is none.
allegation. There is, I can't answer it. I wasn't there.
Because there isn't. No. You don't get to say that. You don't get to say, I don't know the record.
No, I know the record. There's-
Okay, well, where in your allegation, there's a petition, a verified petition.
Yes.
And in the verified petition, it outlines conclusions that he had abandoned and neglected this child.
What act constituted abandonment? The fact that he was living in California, that is abandonment?
At 1 month.
The fact that the child is here and he's not taking care of the child here.
He didn't know about the child until after the child was born because the
That's
mother
true.
moved here.
That's true.
So how is he at fault for not knowing that?
He's not at fault for not knowing that, and he did come immediately to contact us.
Counsel, I keep coming back to this, and let's just make sure that I understand. When you file a verified petition in a civil case, an attorney bears responsibility to ensure that everything to the best of their knowledge contained in that petition is true and correct under penalty of Rule 11 sanction. Here we have a petition that's filed. In this matter, a father who submits to the allegations in the petition, but DCS was aware the only thing that was valid in regard to father was whether or not he was biologically baby's father. So why did DCS include all of the abandonment, unfit parent allegations in that dependency petition?
I can't answer that. I don't know.
Okay. But you agree with me that that is not a proper representation to the court?
I would have to go back to the fact that the father is not here to take care of the child, and the child is here under the custody in Arizona, under the custody
So
of Arizona.
that's the only evidence that's the only evidence you can point to
Yes.
that supports the
And counsel, let me
let's-
just...
And he submitted
And,
it.
wait a minute, let's be clear. He didn't bring the child to Arizona.
Did not.
I mean, it came with the package.
Yes.
And so he had no control over that. He could
No.
not keep mother
No, he did
in
not.
California.
No.
So she makes representations to him, you are not this baby's father.
Yes.
And it wasn't until her husband told him that the baby was in DCS custody
Yes.
that he contacted DCS and said, hey, I think I might be the father.
Correct.
So where's the fault? Where in that time span does it show neglect or abandonment from this father?
I don't think it does. I think the dependency is based on the fact that the child is here. Father is not here taking care of the
Okay,
child. They can't
so-
send the child to California, so someone has to step in and take care of the
The
child.
dependency filing was a placeholder, is what you're telling me, until you could sort this out? I'm wondering, is this a procedure by DCS that we're going to file this dependency with all of the standard allegations and we're going to verify it and turn it into the court because we need some reason to take custody of this child? Is that what's going on?
I don't think so.
Okay, what is going on?
As I said, we have a child here. The child is in DCS custody, under the custody of the court. We don't know who the father is. We find out the father is, by the way, we find out in April, not 7 months later. We find out in April who the father is. The father submits doesn't challenge and didn't appeal the dependency. This is where we are.
But you would agree that the state of Arizona has a heightened responsibility to make sure that it's above board, because typically we're playing with unsophisticated litigants. And so father submits to the dependency. Well, I'm not saying that his counsel does not bear responsibility for that, but DCS also bears responsibility for filing a verified petition that is accurate for the court. And would you agree that all parties kind of failed on that?
I would say that they overreached a little bit.
And the court, I mean, as long as we're placing blame,
Yeah.
the court had to make, whether it was submitted or contested in a hearing, the court was obligated to review and make factual findings, correct? At the dependency stage. The court doesn't just get to say, oh, it's been submitted, they have an independent obligation to say, yeah, there's facts here to
To
support
consider
it.
it, yes.
Okay, so they had their DCS report and they had the statement in the petition.
Yes.
That was a conclusion, and I've read that report. There is not one factual allegation against father in the report that was submitted. I mean, that's why we ordered it. And so the court makes a finding that is not supported by any facts in the record. Because she made a finding saying, oh yeah, he's dependent for abuse and neglect. And at that point in time, there were no facts to support that.
Well, that may be true, but I'll point out, as you pointed out earlier, they didn't appeal from the dependency.
Agreed. I totally agree.
We're just trying to figure out how we got here. And so, and I know this is, you didn't do this, you didn't do this. It's really hard to look back, and we're all looking back trying to figure out what was in other people's minds at the time. When we move forward to the finding of paternity, the dependency is working, he tries to visit. What is DCS's responsibility for providing the service of getting him here for visitation when he is a low-income single dad?
Well, there was the testimony from the case manager that there is no program in place. DCS,
That's not
provides
the
services.
question. The question is what's the obligation on DCS. They may not have a program, but that means they're failing if they ultimately have an obligation.
Well, and I would say in this case, father showed that he could, in fact, earn money, and he admitted that he could.
And, people have the ability to earn money, but you also have to put food on the table, roof over your head, all of those things. So let's back up. We have the ICPC home study says dad is okay. Why wasn't child returned immediately?
Because, and this is conflict in the record on this, either California requested a transition plan. That's the case
There's
manager.
nothing in the ICPC that says that.
No, there isn't. That was testimony, was that the case manager testified that California approved the ICPC, but they wanted a transition plan, and father agreed to it.
But that testimony is contrary to DCS regulations that require any communication between the sending and receiving state be noted, correct? And there are no notations in any of the records I've seen that would indicate that she noted that. So that's a statement that's made, what, a year and a half after the event?
That was at the most
second
recent trial. That was at the
Correct.
second trial. And at the first one, she indicated that the court had ordered it, that there was some discussion, that there had been some discussion. The child was wary of being around new people, and so they wanted to transition the child in, and that the court ordered. I could not find an order, and the minute entry just says discussion is held, so I don't know.
Once he was approved, DCS was aware that even though we had submitted to this dependency, that none of the allegations were true, and father was a good placement for that child. Under what authority did DCS continue to maintain custody of that child? That's what I don't understand. Because typically, when you have one good parent, the goal is to get the child to that parent, because it's their constitutional right to parent. So if DCS knew this was a good place, why was the child not returned to the father?
And you're talking about
After
the initial.
yes.
And all I can respond to is what I just did, that they felt that there was a need for a transition.
I understand that's the practical, but what authority did they have to require that? Is there something that says DCS can require a transition plan between a foster placement and a biological parent who has no unfitness concerns? Where does that authority come from?
I do not know of any regulation authority.
Okay.
Yeah. What you said that California was asking for a transition plan. Were they? Does the record reflect that they needed or were insisting on a transition plan, or were they asking if DCS had any requirements that DCS felt needed to be fulfilled before they could turn the child over?
All I know about California requesting a transition plan was the testimony of the case manager who said California approved it, but they wanted a transition plan.
And that's
There's no
case-
further information about that.
Okay, so
And it's inconsistent with the
It's inconsistent
actual
with the earlier testimony.
ICPC itself.
It's not in the ICPC. I don't know that I'd say it's inconsistent with, but it's
Well,
not
the
in there.
the original ICPC, and correct me if I'm wrong, when I was reading that original ICP, the part that we have, it specifically says, send
You can
the
give the
kid over, tell us
Give us
if
the
you
things.
need any services. I mean, they didn't even recommend any additional services that would be necessary.
In that one, yes, that's true.
Yeah, I'd like to back up before the first ICPC. Once paternity is established, and there's no evidence in the record that father is unfit, what authority does DCS have to not immediately turn the child over to father?
Well, I think that's the same question Judge Campbell asked, if I'm understanding you correctly, and I'm not aware of the authority that you're looking for authority.
So-
The reason was they wanted a transition plan because
So-
the child was wary of new people.
So DCS acted inappropriately, everyone said wrong, they acted inappropriately in not returning the child at that point.
instead of
Hold on,
inappropriately,
Hunter.
let's say excess of authority.
Okay, in
In
excess.
excess of authority.
I want to hear her answer.
Oh, sorry. I didn't.
No,
She
you can
didn't want to answer.
Thank you very much.
That was a friendly amendment to the
Okay.
question.
I'm just amending.
Well, and I'd also point out, they have not challenged the applicability or anything about the ICPC, even in the
Hold on,
trial court or
we
an
get to
appeal.
answer the question.
I understand Father's counsel may not have acted as he should have, but given that, what authority did DCS have when it realized we've got no basis for our allegations? What authority allowed them to keep the child?
Once the ICPC was
No.
completed? Oh, earlier on.
Once paternity was established.
I think at that point, he had submitted, or he submitted at the same hearing, at that point they felt they needed to do the ICPC. Because the child is now dependent, they can't send the child back to California. I think that's what was
Well,
going
hold
on.
on. I don't want to get bogged down in this because I want to move to another question. But isn't technically, you can be dependent and still have to be placed, you just have to have services in place.
I'm sorry, I don't understand the question.
If you can, a parent can be found dependent and still have dependency proceedings going against them and still be the placement
Yes,
of the child.
that's true, yes.
So to Judge Howe's question, theoretically, you could have placed the child, even though it was dependent, you could have placed the child with father at that point in time, right after paternity, but you didn't know what services were needed at that point in time.
That's true, yes.
But you did know what services were needed, zero, after the ICPC came in. Now, now I want to fast forward to the actual severance hearing that we're at here today. I read Alma S. to say that that first of all, in the two-step process, you first have to find a parent is unfit.
Yes.
Unfit in one of those categories. How is father unfit in this case?
Well, they terminated on the 15 months, and the only concern with father at the beginning, at the end, were concerns with what the ICPC in California found, but at the beginning, the concern was he doesn't have a relationship with his child. He has no parental relationship with his child. And that's all he needed to do was develop a parental relationship with the child.
But that goes to best interest, and not unfitness.
I would disagree. I mean, having a parental relationship with the child is part of being a fit parent. If you're concerned about the bond with the foster parent, I would say, yes, you're right. That goes to best interest.
Okay, well,
but in terms of a relationship with the child and the parent, I think
let's play with
goes
that
to
for a minute. So you're telling me that an international executive who lives in Scottsdale, Arizona, and has all the money in the world and has nannies taking care of a child, and the mother passes away, that you're going to swoop in and take this child because that father doesn't have a real parental relationship with an infant?
No, but the child at
Well, you
this
said
point
that was the
child is
unfitness.
already in the custody of DCS, so they have a responsibility to ensure that they're placing the child in a safe environment. If the child doesn't have a relationship with the parent already, it's in.
But you're saying that in my hypothetical, that person is unfit because he doesn't
No,
have
I'm
a
not saying
parental
that person's-
relationship.
no.
So,
Well-
anytime a woman has a child, lies or deceives the biological father, it hides paternity from the father. The father is presumptively unfit because when he finds out, he necessarily doesn't have a relationship with the child, so he's presumptively unfit.
No, I wouldn't say he's unfit, but there would be some proceeding at that point.
How is it any different here?
The DCS is already in charge and already has responsibility for this child. The child's in DCS custody under the jurisdiction of the court. They can't place the child somewhere without knowing it's a safe placement.
So let's do a different hypothetical. This child, fast forward, is 6 years old. Mother is not fit. DCS takes the child into custody. Father is determined to be a person. There's no challenge about paternity. We know who the dad is. He's not involved. What would DCS's first action be in that circumstance where child can talk? Mom says, no, he's the dad, he just isn't involved. What would DCS's first call be? Wouldn't it be to dad to say?
Yes, especially if the child knows dad.
And wouldn't we just simply release the child to dad? What steps
I think it
be
would depend
required?
on whether the child has a relationship with father already. I think they probably would, if the father if it was a custodial situation, the father had some kind of
Let's
legal.
not say custodial. Let's
Okay.
say child is 5, had seen dad periodically, maybe when they were 2 and 3.
Okay.
Had not seen dad for 3 years. Mom is arrested, put in prison. Kid comes into care. What happens?
I think they would contact father, and they probably would check before turning the child over to father to make sure the home is sufficient and, do a home visit at least.
And I don't think that's necessarily inappropriate, but my question is, under what authority do they get to maintain custody when a biological parent is available? Is it only when a dependency has been filed, when child is in care? And how do they derive that authority to deny a biological parent of custody based solely on lack of bonding?
Well, it's based on the 15-month ground. and-
This isn't what we're
Okay.
talking about. I want, in my hypothetical, you to tell me how DCS does that. Father shows up, says, give me my child. Hadn't seen him in 3 years. What does DCS do?
I think DCS, he's the legally fathers, I think probably DCS would end up turning him over, but would check first to make sure that this is a safe environment. If it isn't, then perhaps there's a different answer.
Under what authority would they delay the transfer of custody? Is there a statute? Is there a rule? Is there internal processing? How does DCS have the authority to do so? It has to be granted that authority, and that's what I'm really struggling with is, sure, it's a good idea. Make sure it's a safe place. Make sure the kid's going to be taken care of. All of that sounds lovely. But that's against a constitutional right to parent your child. So where do we get that authority?
As I said before, I don't have the answer.
I don't know either.
All right. Thank you very much for your argument.
Thank you.
Ms. Carroll, any final word?
What I'm really concerned about is with this ICPC. And
The first one or the second one?
both.
Okay.
Because the first thing she said when she got up on her argument is, well, we can't return him because we don't have a valid ICPC.
Today.
Today. Okay? And the problem is this. The first ICPC was granted. And at that time, I mean, father could have been doing marijuana. Marijuana is legal in California. It's legal for recreational purposes. But the father went beyond and got a medical marijuana card, so technically he'd be legal in Arizona. I don't know if DCS has the authority to stop him from doing marijuana if it's legal in one state and not
Let's
ours.
not get off on that tangent.
Well, yeah.
Let's stick to this. If the severance is reversed, what happens, in your opinion? What can DCS, what are they authorized to do?
Right. I think because of the ICPC, they have to get, because this case has gone through dependency, they have to get the permission of the state that's taking the child. I don't think that they have authority just to drop this child off, unless
Today.
I don't know.
Well, that's different than
Yeah.
what you told Judge Howe when he asked you that question earlier.
Well, you asked me what I wanted to happen, and that's what I would want to happen, and I guess how it would be crafted.
What ruling are you asking?
Yeah. Right.
Let's ask it differently. What
Yeah.
ruling do you want from this court?
I suppose if the court found, gosh, this is a tough question, because if the court goes back in time and says there's no dependency, there's no severance, and whatever,
Hasn't that ship sailed?
Well,
I mean, we
think
can
that
look and
has.
say there's nothing in the record to support it, but guess what? You didn't appeal it, so
Right,
too
right.
bad, so sad.
Yeah.
But isn't the only issue before us of whether we have sufficient evidence to affirm the severance or not?
Yes, and if the court finds that the trial judge was in error, it would go back. It would be mandated back to the trial court. The trial court would have to reinstitute a family reunification plan. An ICPC would have to immediately be ordered, and then as soon as that ICPC is approved, that child would be sent back. That's what I think would happen. And I think that would be appropriate. As far as the second ICPC, as I said, the only things that California was concerned about was marijuana use, which, as I said, it's now legalized. And second was his unemployment, which was the same. He had the same kind of unstable employment when it was approved. So I don't think anything changed really from the first time to the second time. And I believe that if the circumstances are the same, that ICPC should be approved and that child should be returned. Now, that may take a month or so because you already have the ICPC out there. They just have to file and say, look, the Supreme Court, the appellate court now wants this child to be returned to parent. And they're going to go out there, do a preliminary investigation, and if they find that it's appropriate, they're going to return that child.
All right. Thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your arguments here today.